And with that, I would like to introduce our speaker. Connor Burton is an attorney at Messick Law PLLC, and he will be talking to us today about demystifying CHIPS and TPR matters. So I will turn it over to you.
Thank you. Share that. So welcome everyone, and thank you for being here today. And welcome to anyone who's watching this on repeat, hopefully sometime warmer than it is today on this cold and soon to be snowy February day. My name is Connor Burton. I'm an associate attorney at Messick Law in St. Paul, Minnesota, and I handle the CHIPS matters for my firm. I first gained experience with CHIPS matters as a law clerk for Judge Christine Long in Rice County. It was a unique experience, unique situation, wherein Rice County has a very active child protection calendar. And before taking the bench, Judge Long was a county attorney in charge of child protection. So I benefited greatly from that experience. While it's not an area I thought that I'd practice in, I quickly developed an affinity for it, and would invite all of you to maybe give it a chance if, let's see here, give it a chance, because it can be very rewarding. So today we'll be covering the CHIPS process, the termination of parental rights process, and touch on the appeals process, ending with questions. If at any time anyone has a question, please feel free to interrupt me. This is going to be a look at the subject from 30,000 feet. And as such, I'm going to focus on some of the more common areas of the law and leave out some of the less common or more complex areas, such as the Indian Child Welfare Act, which we could do a whole series of these on. It's not my intention to express an opinion on any parts of the CHIPS process by choosing to speak about them or leave them out. The decisions were just made based on today's 1-hour format. So, child in need of protection or services, or CHIPS as it's abbreviated. Minnesota has had juvenile courts since the 1950s, with the probate judge being assigned the title of Judge of Juvenile Court in any jurisdiction of over 200,000 people. This is a dynamic area of the law, with updates to the statutes being passed as recently as last year. CHIPS takes precedent over other matters such as custody determinations before a court. And the county attorney in any given district has the right to determine whether a CHIPS or a criminal matter proceeds first. So CHIPS can have a controlling impact on another number of other proceedings before the same judge or other judges. So beginning with the child in need of protection or services process, the goal of the CHIPS process is the reunification of the child with the custodial parent or parents. However, the social services agency in charge is also legally required to explore other placement options. While engaging in reunification efforts. It can be a little bit bipolar at times. The CHIPS process has been described as attempting to assemble a car while it's already rolling down the road. The timelines in CHIPS are fast and unforgiving. It's critical to impress upon your client that delays early on can have far-reaching consequences. So the CHIPS process typically begins with the filing of a child in need of protection or services petition. Typically, the petition is drafted by the social services agency in the county it's being brought. When that happens, the county attorney's office reviews and signs off on the petition. However, the rules of juvenile protection procedure indicate that a petition can be brought by any responsible person. The petition filed with the court in a juvenile protection matter must contain an affidavit or sworn statement describing events or conditions known firsthand by the affiant. This statement of facts, if taken as true, must be sufficient to prove one of the CHIP's statutory bases as enumerated in Minnesota Statute 260C .007 subdivision 6. Well, there are a total of 16 statutory bases laid out in MinStat 260C 007 subdivision 6. Typically, you'll see 3 use far more than the rest. Pren 3 could be summarized as the failure of the parent to provide for the child. It reads, the child is without necessary food, clothing, shelter, education, or other required care for the child's physical or mental health or morals, because the parent, guardian, or custodian is unable or unwilling to provide that care. Pren 8 can be is often seen when parents have their own mental health challenges that are interfering with their ability to care for the child. It reads as the child is without proper parental care because of the emotional, mental, or physical disability or state of immaturity of the child's parent, guardian, or other custodian. Pren 9 is best summarized as the criminal activity or dangerous home situation. It reads, the child is one whose behavior, condition, or environment is such as to be injurious or dangerous to the child or others. An injurious or dangerous environment may include, but isn't necessarily limited to, the exposure of the child to criminal activity or drug use in the home. It may be clear that these 3 subsections have a substantial amount of overlap and are often used as a trifecta in a petition. If you see one, you are more than likely to see the other 2. Petitions do not have to indicate what behavior meets what section, and there's relatively little common law to flush out CHIP's adjudications. After the petition is filed, it is the petitioner's burden to have it served out. Herein lies one of the first quirks of CHIPS. There are parties and there are participants in CHIPS matters. Parties include the custodial parent, a guardian ad litem, the child's legal custodian, if not the custodial parent, the petitioner, and any other person who is deemed by the court to be important to the resolution that is in the child's best interest. Participants include any parent who is not a legal custodian and any alleged, adjudicated, or presumed fathers, any grandparents with whom the child has lived with within the 2 years preceding the filing of the petition, relatives or other persons providing care for the child, and other relatives who may request to be involved. In my experience, the most common participant is the alleged father. This is typically a man who had the child out of wedlock. Possibly he's listed on the child's birth certificate. Maybe there's a signed recognition of parentage. Possibly has informal visitation arrangement with the child's mother. However, he's never gone to court to formalize his custodial rights. In that situation, the goal of the CHIPS process is not reunification with him. And this can be frustrating, especially when the petition doesn't pertain to his actions. Parties are required to admit or deny the petition. Parties are required to participate in a case plan, even if reunification with them is not the goal. Participants are not required to do these things. However, the county can often find creative ways to compel a participant to work with them, such as withholding visitation with the child. Participants can move to become a party, and the county can actually move to have a participant made a party. If, as part of the events constituting the CHIPS petition, the child was removed from their home by law enforcement, the court must hold an emergency protective care hearing within 72 hours of that removal. As part of this hearing, the court may admit any evidence, including reliable hearsay and opinion evidence, that is relevant to the decision of whether to continue the child in protective care or return the child home. The court must determine if the petition establishes a prima facie showing that a juvenile protection matter exists and that the child is the subject of that matter. This determination is typically made on the face of the petition, possibly with some testimony by the affiant. Next, the court must make a determination that the child or others would either be immediately endangered by the child's actions if the child were released to the care of the parent or legal custodian, or that the child's health, safety, or welfare would be immediately endangered if the child were released to the care of the legal custodian. If the court makes these proceedings, the CHIPS matter proceeds to the next step. Every party and participant has the right to be represented by counsel in a juvenile protection matter, including through appeal, if any is noticed. The process to obtain court-appointed counsel is substantially similar to those seeking court-appointed counsel in criminal matters or the IFP process. In many counties now, a court-appointed counsel is assigned to a parent at the EPC hearing, regardless of whether or not they have the means to retain counsel. Given the short time frame between removal of the child and the EPC, this allows for the parent to have counsel and explain the process and at least the next preliminary steps. If the parent then applies and qualifies for court-appointed counsel, the EPC attorney typically continues on in their representation. An admit-deny hearing is held next. An admit-deny hearing is a hearing at which the statutory grounds set forth in the petition are either admitted or denied. The rules require admissions by the custodial parent and a biological parent who may not be custodial but has been made a party. Anything other than an admission is typically considered a denial. A party may admit to all of the statutory grounds set forth in the petition, or with the agreement of the petitioner, enter a partial admission, with the petitioner dismissing the remaining sections. I found county attorneys are typically not overly picky about what section is admitted under, as long as there is an open admission. If they're pending criminal matters, some courts are willing to entertain an admission, avoiding admissions that would self-incriminate. If this is not possible, the court, with the agreement from the county attorney, may grant an immunity. Make sure that if this is a concern, that the immunity has been agreed to first before an admission is placed on the record. An important point to be aware of during discussions on whether to admit or deny is your client's CHIPS history. Typically, previous cases involving the parent are listed on the CHIPS petition. However, If you don't see that section, I would advise speaking to the county attorney about this. We'll get into this a little bit more during the permanency progress review hearing section. The CHIPS rules allow for some discovery without court intervention. The petitioner must allow access at any reasonable time to all information, material, and items within their possession or control which relate to the case. The petitioner must disclose to all parties the names and addresses of the persons intended to be called as witnesses. This includes expert witnesses. You don't have to wait until it's apparent that things are headed to trial to begin your discovery request. It's often helpful to request petitioners' files on a rolling early on and make sure that they're given on a rolling basis so that you're well informed of what's happening in the case. Some discovery requires a court order. The court may order a party to submit to a physical or mental examination by a licensed professional of the moving party's choice. The report resulting from that examination or any medical records that the petitioner may want must be compelled by a court order. Typically, this can be done by requesting releases of information so that social workers can obtain these records themselves. The pretrial hearing comes next. It's often an overlooked part of the lead up to a CHIPS trial. The pretrial hearing must be held at least 10 days before the beginning of trial. The pretrial hearing is typically used to determine if there are any outstanding issues that need court intervention prior to trial. However, it can also be used to narrow the scope of trial. Facts not in controversy can be stipulated to, evidence and exhibits can be stipulated to, and if possible, issues can be narrowed down. As an example of this, if allegations, let's say, of drug use were being made in the petition, but testing has confirmed that there was no such use, that issue could, by approval of the parties, be struck, possibly resulting in the removal of a basis, a statutory basis. Also, as discussed above, if there are any pending criminal charges, this would be when discussions regarding immunity should be brought to the attention of the prosecutor and the court. The CHIPS trial is required to begin within 60 days from the date of the emergency protective care hearing or the admit-deny hearing, whichever was earlier. The petitioner bears the burden of proving that one statutory basis exists by clear and convincing evidence. As it is the petitioner's burden, the petitioner goes first. The regular rules of civil procedure and evidence apply during trial. Depending on the number of parents and the complexity of the petition, it's not uncommon for CHIPS trials to take 2 to 4 days. The court may allow for oral closing arguments, or it may allow written closing arguments with proposed order. Written closing arguments are generally submitted simultaneously. The court has the authority to allow up to an additional 15 days for the parties to draft their closing arguments. Within 15 days of the close of trial, or within 15 days of the filing of written closing arguments, the court must issue its order. If the court finds that the petitioners failed to meet their burden, the court will dismiss the petition. However, if the court finds the petitioner has met its burden, the court will find that the child is a child in need of protection or services and may move the matter on to disposition hearing. I say may here because in rare circumstances, the court has found that the child in need of protection or services, but withholds adjudication for a period of up to 90 days. This is typically done by agreement of the parties. However, the court has the right to take a wait-and-see approach if the family is voluntarily engaging in services, and the issue seems close to resolution. To the extent practicable, the court may conduct a disposition hearing and enter a disposition order the same day it makes the findings that a statutory ground set forth in petition has been proved. However, the court generally looks to the county for disposition recommendations, and the county may not have them ready at the time the court order is issued. So a disposition hearing may be held shortly after adjudication. This has the added benefit of giving the petitioner time to craft the case plan or out-of-home placement plan and run those documents by counsel for the parent. When the social services agency is the petitioner, the agency must file a case plan and/or an out-of-home placement plan for the child and the parents. The court must approve and adopt the plan on the record. In short, the case plan provides the custodial parent with the steps they need to take and what they need to accomplish or demonstrate to end the CHIPS action. The out-of-home placement plan, if the child is out of home, provides the specific reasons for the placement of the child in foster care, and when reunification is the plan, a description of the problems or conditions in the home of the parent or parents that necessitated the removal of the child from the home, and the changes the parent or parents must make to demonstrate the child can be safely removed to returned to the home. The court will conduct review hearings on case plan or the out-of-home placement plans at a maximum of a 90-day interval. This can be shortened at the request of the parties. Typically, a shorter review interval occurs when there's either a good deal of progress or a great lack of progress. As part of these review hearings, the guardian ad litem and the social worker will file reports laying out their observations at the parent's progress and will change any recommendations that they have based on that progress. The parent's attorney will be asked to provide the parent's opinion on the reports. The parent's attorney has the right to submit their own reports and evidence prior to the hearings. In its order following the hearing, the court will typically make some findings regarding the status of the case. These include, but are not limited to, the parent's progress in completing their case plan, whether or not the child's current placement is in the child's best interest, that the county is making reasonable efforts to reunite the family. The county will oftentimes ask the court to make this particular finding. Don't let this just be something that's found without some kind of pushback. If your client is telling you that they're waiting on a referral from the county, or they've been trying to get a hold of their caseworker with no success, or that some aspect of the report regarding efforts is incorrect, make sure that the court knows. If your matter does move to termination of parental rights or some other permanency option, one of the elements that the county has to prove is that they made reasonable efforts to reunification, and they will fall back on these orders as their proof. As stated earlier, the goal of the CHIPS process when the child is, the goal of the CHIPS process in general is reunification of the family. Until a judge relieves the county of that obligation, that is the ongoing goal. In my time as a clerk, my judge considered some of the following questions before making a reasonable efforts determination. What caused the condition that led to the removal? What services were offered, and what services were actually provided to remedy that condition? Were there any additional services that could have been offered? And can the child safely be returned to the home now? And if the answer to that is no, then why not? At or before the 180-day mark, and then depending on the age of the child, prior to the 360-day mark, the court must determine if the parent is making sufficient progress to continue towards reunification with the child, or if the county should seek placement of the child elsewhere. These time measurements begin when the child is first placed out of the home or taken out of the parent's custody. However, they include all time that the child has been out of the home, out of the parent's custody in the last 5 years. Oftentimes parents who have history with the CHIPS process start the process out near or at the end of their permanency timelines. So before entering an admission or a denial at the admit-deny phase, it's important to know how many days left your client has. If they're nearing the end of their timelines, is the county going to really work with them? What was the parent's previous involvement in CHIPS like? I have seen parents who have been either out of time or really close to the end of their timelines. However, in their previous CHIPS cases, they were engaged, they worked well with the county, they had a good relationship with their worker, and so the social services agency has requested that they get extra time. The court has given them extra time. I've also been in and observed situations where if the county has had an acrimonious relationship with my client in the past, that they've moved almost immediately from CHIPS to permanency proceedings. A request to begin termination proceedings typically comes from the petitioner through their submitted reports. The petitioner will be required to point to a lack of engagement or progress compared against the statutory timeline. The 6-month mark can hit very quickly in these actions, especially if you've gone to trial. That's 2 out of the 6 months that potentially have been used. And if you do go to trial and the court decides against you, it's important to coach your client that at this point it's time to hit the ground running. If things have gone well and the custodial parent has completed or made substantial progress on their case plan, then the CHIPS matter may be closed. The court can terminate jurisdiction over a CHIPS matter once the child has been reunified with the custodial parents. It's not uncommon for courts to order a period of protective supervision prior to the closure of a file. This would be when the child is back at home. However, the agency maintains the right to drop in and keep tabs on the family. If the court has not terminated jurisdiction over the matter and the county is requesting permission to move to permanency, then the next step would be for the county to file a permanency petition. Very often this is a termination of parental rights petition. Oftentimes a request to file a permanency petition will come from the county at an intermediate disposition hearing or the permanency progress review hearings. The request is usually made both in the requester's report and then orally at the hearing. If the request is made and your client doesn't agree with it, presenting evidence of progress in their case plan might sway the judge not to grant the request. However, I've typically found that once a request is made, judges typically grant the request. A termination of parental rights petition begins with a new court file. The CHIPS and then the TPR file will then track each other for hearing purposes. The TPR petition has many of the same requirements as the CHIPS petition, a statement of facts sworn to that, if true, would meet the statutory bases for termination of parental rights. Minnesota Statute 260C-301 subdivision 1 has the 10 statutory grounds for termination of parental rights. Besides for termination of parental rights petition, occasionally the county will file a permanent transfer of legal and physical custodian petition. Essentially, if this is granted or agreed to, this transfers legal and physical custody, usually to another family member, maybe a different parent or a grandparent. This kind of transfer leaves the parental rights intact, but leaves the parent without any physical or legal custody. I've seen this offered where a parent has made progress on their case plan, but is still struggling with actually parenting the child. But there is another option available with the family. In theory, this type of transfer does leave the door open for a transfer back to the parent down the road. Well, after the permanency petition is filed, again, we have an admit deny hearing. This hearing shall be held not less than 10 days after the service of the summons and petition on the party. The parties are asked to enter an admission or a denial of the petition. Entering a denial moves the matter forward to trial. If a denial is entered, I would file a discovery request almost immediately after the hearing, just to make sure that the county is on notice that you do want their entire file. Entering an admission essentially voluntarily terminates one's parental rights. The court may, upon petition, terminate all the rights of a parent to a child with the written consent of that parent who, for good cause, desires to terminate their parental rights. The benefit of a voluntary admission is that it does not come with a finding of palpable unfitness as described in Minnesota Statute 260C-301 subdivision 2B4. This particular section of the law allows the social services agency to begin a CHIPS or TPR action against any future children of a parent who's had their parental rights previously involuntarily terminated. For some clients, this can be decisive. If the evidence is such that one's parental rights are going to be terminated, but future children might be an option, it can create sort of a balancing act. Courts may order the parties to engage in a settlement conference, even if a denial has been entered. This meeting would be a last effort to settle and also get any additional information from the custodial parent regarding their family or any preferred placement options. Again, mirroring the CHIPS process, the pretrial hearing must be held at least 10 days before the beginning of trial. It can be used to determine if there's any outstanding issues that need court intervention prior to trial and to narrow the scope again. A permanency trial shall be commenced within 60 days of the admit deny hearing. Again, the standard of proof is clear and convincing evidence. In its order, following the permanency trial, the court can deny the petition, the permanency petition, and dismiss it. The court can refer the matter back to the CHIPS process, or the court has the right to terminate parental rights. To do this, the court must find that one or more of the statutory grounds supporting termination were proven. that the petitioner engaged in reasonable reunification efforts and those efforts failed, and that it's in the child's best interest to have permanency established elsewhere. The best interest analysis includes a balancing of three parts: the child's interest in preserving the parent-child relationship, the parent's interest in preserving the parent-child relationship, and any competing interest. During my time as a clerk and now as a practicing CHIPS professional, I have not seen a post-trial motion. However, the rules do allow for them. For those practicing in civil law, they are substantially similar to what you find there. An aggrieved party, typically a parent, has the right to appeal the decision terminating parental rights. The timelines for a CHIPS appeal or a TPR appeal is much quicker than elsewhere. It must be noticed within 20 days of the issuance of the order. This includes, at minimum, requesting a transcript of the hearing being appealed. The Court of Appeals has held that CHIPS adjudication, termination of parental rights order, and post-trial motions are appealable. However, an order from a review hearing is not appealable. The argument here being that it's not a final order affecting a substantial right. There has been no determination as of yet as to whether or not an emergency protective care determination is or is not appealable. To begin an appeal, you must file and serve a notice of appeal and statement of your case on the county attorney and all other parties. These documents must also be filed with the Court of Appeals through their electronic case managing system, EMAX. Rule 23 of the Minnesota Rules of Juvenile Protection Procedures lays out the requirements if one is interested in filing an appeal. Appellant's brief is due within 30 days after the delivery of the transcript by the court reporter. Add 3 days if the transcript is mailed. The respondent's brief is due within 20 days after service of the appellant's brief. The appellant has the right to have a reply brief within 14 days of respondent's brief. Extensions can be requested, but the Court of Appeals typically holds to their timelines, the thought being that the child deserves to know what their situation is. The record in a CHIPS case is generally long and well prepared. Citing to specific areas, incidents, notes, orders in your brief is key. There's going to be a lot of information. The county is really good at papering a file. It can be overwhelming to a Court of Appeals justice who, is not going to take the time, potentially not going to take the time to dig through a year's worth of reports and case notes and chronologies. So directing their attention to the facts that you think are the most critical is important. Most items for review, for Court of Appeals review, fall into the abuse of discretion standard, which is a tough one to win. The Court of Appeals gives the trial court great deference and credibility and matters of weighing evidence. Some of the more common issues in appeal are sufficiency of the evidence, whether or not reasonable efforts were made, that the record and the findings do not support the trial court's decision, statutory rules, or rule violations, procedural errors, and evidentiary rulings. Legal issues are reviewed de novo. Legal issues and a de novo review tend to find the most traction getting reversals and remand. Oral arguments. You're not required to make an oral argument. If you do, appellant gets 15 minutes plus 5 minutes for rebuttal. If there are two appellants, if both parents are appealing, they must determine amongst themselves how they're going to split that time. Respondent gets 15 minutes, and the court will issue its order within 45 days of either the oral arguments or the close of the record, if there was no oral argument. So we got done a little bit early. I just attempted to cover a whole section of Minnesota statute and the Minnesota Rules of Juvenile Protection Procedure in less than an hour. It's been fast for sure. Does anyone have any questions?
I have a question about discovery and just was wondering kind of how specific you get with your request, since I know everything, does it kind of mirror more or less a request similar to that of a criminal case, or how specific do you make your request to the county attorney regarding discovery?
So I don't practice in criminal law, but I will say that there is a Rule 17 of the Minnesota Rules of Juvenile Protection Procedure governs discovery. There is a form that's spread around amongst the CHIPS protection parents attorneys who that basically request everything. And I mean we get the case notes, down to the daily notes of the social worker. It can be pretty granular. Did that answer your question?
It does. Would there be a way to get the form in outstate? I don't have that form available, I don't think.
Yeah, so I will jump to the last screen. If you want to email me, I can send that to you. Or if it's something that a lot of people have interest in seeing, I can provide it to the moderator, and perhaps she can send it out. So I see, is there a statutory basis to what a reasonable effort is or not? In my experience, no. What a reasonable effort is, banks on. Well, let me step back a second. A lot of times in my experience, the county attorney will just kind of try to sneak it in and say, and is the court making the finding that the county is engaged in reasonable efforts? And a lot of times the judges will just, these hearings are scheduled for 15 minutes. The judges will say, oh yeah, of course, we're finding that. So if you believe that, if in speaking with your client, he's saying, I'm trying to, they're saying that I need to do A, I've been trying to contact them and, to get A completed, and they aren't getting back to me. I would say it's important to present that to the judge and argue that, reasonable efforts aren't being made because, your client is attempting to work the case plan and they're not being met halfway. Yeah, let me go back here. I can also provide the outline or my there you go.
So one of the things that's come up fairly frequently for us at the State Law Library is questions about the new statute regarding reestablishment of the parent and child relationship. And I know you didn't get into that, and I'm sure that there's plenty of detail around that that could take up its own session. But I'm wondering if in just a few minutes you could share if you've had any experience with that and any information about that process.
Yeah, it's as you said, it is new, and it definitely there's a lot of interest by parties who feel that they either want to voluntarily terminate or if in having an honest conversation with a client, say, I think that the county has a pretty strong hand here. I do not have very much experience with it. What I can tell you is that the question is always what's in the child's best interest, and that's going to govern my understanding. And speaking with prosecutors, with county attorneys, is that it's their position that that's really going to govern the process. And so if in a year or two the parent has managed to turn things around and are in a much better situation than they were at during the CHIPS process, they may still face an uphill battle because you have a child who's now settled into their new situation, and what the impact, the court's going to weigh what the impact of having them removed is versus allowing them, just to have contact with the parent, or some other agreement between the parent and whoever the new placement is. Okay. And Mystery, perhaps we can chat more. This looks like a longer question. Maybe we can chat more about that later. See, I think that I'll have to go into some facts here. Any other questions? All right, well, if no one minds getting out a little early, I do was a little bit worried that we were going to run up against the end, but it looks like we went the other way.
Thank you so much, everybody, for attending. The CLE credit information is in the chat, and we will post the recording and slides to our website hopefully later this afternoon. Thank you, everyone, for attending, and thank you, Connor, for sharing and presenting on this really important topic.